Good afternoon, everyone. Let me welcome you to week 4 of our ADR classes, ADR masterclass. I want to specially thank today's lecturer. She's somebody that I have a lot of respect for. Laura and I, we come way back, and we have served at different times on different projects. And Laura is somebody that I admire her tenacity. I admire her deep knowledge in arbitration, particularly in investment arbitration, and Laura's commitment to deepening the practice of arbitration across the world, and it's just not in Nigeria. So I think it's a privilege to have Laura Alakija, lecture us this afternoon at the week 4 of the this ADR masterclass. If I were to pay Laura, I'm sure that we cannot afford to pay her. So Laura, I want to thank you very much for donating your time and, of course, willing to share your knowledge. I've always been very passionate, about us deepening the practice of arbitration and developing the next generation of arbitrators and counsel. And this is essentially what we have been doing in the last 4 weeks. So, Laura, thank you very much. To our colleagues in the class, I want you to please pay rapt attention, but not just that. Please engage with Laura, once she finishes her paper on practical issues. For me, I've always said one of the best ways by which you can learn is when you raise practical concerns, but you can only raise practical concerns if you are paying rapt attention. And for those of us who have some level of practical knowledge in arbitration, I think this is one of the best times to also engage and deepen knowledge in that regard. So welcome everyone. I hand you over to Calvin, who will now read out Laura Alakija's profile, and then we kickstart today's masterclass. Good afternoon, everyone.
Thank you very much, Dr. Tolu Aderemi. Here's the profile of our keynote speaker for today. Ms. Laura Alakija is an eminent independent arbitrator and ADR expert with over 2 decades of experience in dispute resolution and commercial transaction. Their cross-section expertise include energy, infrastructure, and ICT, acting under prominent institutional roles such as ICC, LCIA, and ICSID. A respected global voice, Laura served on the ICC Commission on Arbitration and the Chartered Institute of Arbitration Global Approved Faculty. Her thought leadership is reflected in her pivotal contribution to Africa Arbitration Academy's protocol and model bilateral investment treaty, consistently recognized as a lexicology who is who arbitrator future leader 2024 to 2026. She was also named amongst Africa's 30 most promising arbitrators. From her early recognition as a 40 under 40 rising star, Laura has established herself as a transformative leader in the international arbitration landscape. Ladies and gentlemen, our speaker for today, Mrs. Laura Alakija. You're welcome, ma'am.
Thank you very much. I'm most grateful. I'm sorry, can everyone hear me?
Confirm, ma'am, we can hear you.
Thank you so much for the kind introductions. Also, very many thanks, Dr. Aderemi, for those kind words. I was wondering whether he was talking about me or somebody else, but since my microphone was muted, I could not raise an objection. I'm most grateful for the kind introduction and for the opportunity to engage with everyone in this class for the next 90 or so minutes. I was very excited, as always, when Dr. Aderemi reached out to me regarding this course. Not because I like not because I like work or I'm a glutton for punishment or I'm looking for extra to add to my workload, but because Africa is on the rise, and every opportunity for us to rub minds together to improve our respective and our collective standing as professionals on the continent, as the vanguards of hope, as the channel for growth and development across the continent, is an opportunity that I honestly don't know how to say no to. So I was quite excited and happy to take up this challenge. I suspect that I've bitten off more than I can chew, but I am optimistic that with your help, this session will be worthwhile for everyone. So I'm going to ask you very quickly to work with me, just because that will give me a sense of what it is we are doing together for the rest of this session. I know that this is week number 6 now. So if you can very quickly, if you're present and you're paying attention, if you can very quickly tell me if you've heard about investment arbitration before. Just type in the comments one word, yes, and then another phrase, 2 phrases, or 1 sentence, let's say about 5 words that describes what you know about investment arbitration. So just short, if you can quickly drop in the comment section, yes, 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 for those who have heard of investment arbitration, and then what you know about it. So for example, if what you know is the form of dispute resolution it is, or the parties involved, or if you've seen it in a course before, or if you've participated in a case. Just very quickly, and I am going to plead with everyone to be as responsive as you can. And if you've not heard of it and you don't know anything, no, not familiar is a good response. There's no right or wrong answer. I'm pleading, please, everybody. This will help us determine how our conversation will go. So I'm looking in the comment section. Thank you, Marvelous. I'm waiting for urgent comments. Yes, thank you, Juliet. Urgent comments, please. Quickly, quickly, quickly. Not familiar, thank you. Not familiar, thank you. Excellent, thank you, Joanna. Thank you, Modupe. Thank you, Hawa. Please, I'm looking forward to all the responses. Excellent, not familiar, not very familiar. Thank you. Okay, I see a yes. Thank you, Opeyemi. Read about it. Thank you, Juliet. Excellent. Thank you, Favor. I've not heard about it. Thank you, Asobara. Celine. Thank you, Ademola. Excellent. Thank you, Oluwaseun. Annabelle. Perfect. I'm so glad to see all these responses. This is a very, very this is very useful. Let me put it that way. Not familiar. Thank you, Blessed. I think, okay. Excellent. Perfect. Thank you very much. I am so grateful for all these responses. So I'm going to dive straight into our presentation for today. And from the responses I've seen on the group, there are few people that are familiar with investment arbitration and quite a number of people that are not. And for those that are not, have no worries. I will make it as foundational as I possibly can. And for those who are familiar with investment arbitration, I'll crave your indulgence to bear with us a little bit. If I say anything that is a little bit elementary, please just bear with me. I am sure that between the elementary aspects and the more technical aspects of our conversation, we will be able to touch on something that hopefully will be useful for everyone. Okay, thank you very much. So I'm going to share my screen now. Please do not mind the way my presentation looks. It is very plain Jane. There are no frills. I don't know, maybe because I think this is a serious subject and I didn't want to decorate the slides, but that notwithstanding, I think that it covers everything we need to say on the subject matter. So So I'll be sharing my screen in a moment. I'm sorry, I need the host to allow me to share. Is that possible? If it's not, I can work without sharing the slides, quite frankly. So please let me know if it is possible. If it's not, that's okay. I will just start.
Sure, the host can let you share, Laura. Calvin, can you please give Mrs. Alakija sharing?
Okay, thank you so much, Doc. I appreciate. While Kelvin is sorting that out, I'm just going to start. So investment arbitration, and I'm sure that you've had a few introductions, so you know what arbitration is, so I will not go into that. But investment arbitration essentially is arbitration that is mostly related to investment disputes, as the name provides. And I'm sorry to give a lawyer definition because we always use the word to define itself. I don't understand why we do that. But investment arbitration mostly deals with disputes that are connected to investments. Maybe I should backtrack a little bit and give a little bit of history. And I'm sure that when I share my materials, everybody will get them. But as we know it, cross-border trade has been with us for centuries, for many, many centuries. It's not a recent thing. And because investment arbitration has to do with investment across borders, this is why I'm going back that way. But, investment arbitration as it is today hasn't always been with us in the form that we have it. And I'm providing all this context so that when we discuss, the makeup of investment arbitration, it will be a little bit clear to all of us. Maybe I should pause to sort of give a roadmap. So we'll start with the background and history of investment arbitration, and then we'll talk about the sources and the system or structure. And then we will talk about jurisdictional building blocks. Jurisdiction is a big deal in investment arbitration, and you'll understand why. And then we'll close with protections and defenses. I think that by the time we've covered that end to end, you should have a fair sense of what investment arbitration is and how it works. I should say that with the best will on earth, this conversation cannot be anything more than a teaser. So everything I say to you is something that you need to make out time to go and study, research, take courses if you can, find opportunities to do cases if you can, because investment arbitration is that much of a complex and technical field that you need to spend a little bit more time getting to understand the subject matter and to take every opportunity you can to interact with it in a practical, if you have the opportunity to interact with it practically. So that said, I was saying that trade and investment have been with us for many centuries. That's not new. Investment arbitration hasn't always been in the format that we see it today. And, from as far back as 2500 BC, humanity was doing trade across borders. So if you go back to Quranic and biblical times, you will see that there were empires that were conducting trade across borders, civilizations as old as Rome or Egypt, back then involved themselves in a lot of cross-border trade. And because merchants were going across borders to buy and sell goods, going across border to buy goods to bring home and sell was easy. That wasn't a problem. But if you were now taking your goods or your services to another location to go and sell it there or to render those services there, then somebody says they cannot hear me. Is that the case? Is everyone unable to hear me? I need someone to unmute and say if they can hear me or not, please.
We can hear you.
Oh, excellent. Okay, whoever cannot hear me, can you just log out and log in again? It may be a connection issue. Thank you so much for your responses. So I was saying, but merchants found that every time they had to go and deliver their services across border to other locations, if you were not going to stay there for the duration of your entire transaction, then you needed local people in that location, either local people or you left your people behind there to transact business. Now, when you left your people behind to transact business, it used to happen every now and then that some violation of their right or contractual breach or some local skirmishes would affect your business or your goods. And the challenge was, how then would a foreigner in this land find protection? How do they secure protection? And these were the early things, or these were the early requirements for some kind of investor protection for cross-border trade. And in the earliest years of cross-border trade, it then happened that, states, as an individual or as a private business person, you could not really go to the government of that state or to the king or, whatever authority was in charge and say, my business, your citizens have maybe consumed goods and refused to pay, or they've destroyed my merchandise and I'm holding you accountable so that you will pay me back. It was impossible for an individual to do that. So what then used to happen was merchants would go back to their home state, and then the home state would use what was known as diplomatic protection to then engage with the host state. So I will be mentioning a few terms and asking you to note them. And some of the early terms you should note. If you have a pen and a piece of paper, write on top of it jargon buster. Jargon, J-A-R, I'm going to type it in the section. And a jargon buster is just a list of all the terms in a new practice area that you're trying to learn. That's my trick for getting familiar with any new space. When I get in, I want to understand the industry so I understand the key terms. So if you have a notepad and a pen, write jargon buster and then write down these words. So in investment arbitration, some of the first players on the scene were the host state and the home state. The host state is the state where you go and contract your business. The home state is obviously the home country of the businessman who has traveled across border to go and transact business. So some of the earliest terms or some of the common terms you will keep hearing in investment arbitration is home state and host state. When you hear home state, is the home of the investor. When you hear host state, that is where the business is domiciled. That is where the investor went to and did their business. So if you have a trade agreement between two countries or two states, at every given point in time, when citizens from those two countries contract or carry out business in the respective countries, and another set of words you will hear is contracting party. So for every international instrument or international trade agreement, they are generally referred to, the states are referred to as contracting parties. So the citizens of the contracting parties will cross border and carry on business in the respective states that are signatories to that agreement. So at every given point in time, when you have a foreign investor in another state, there are two entities that exist in that. There are more than two. There are three entities that exist in that relationship. There is the investor, there is the host state, and there is the home state. So let me remind you of those terms. You have host state, you know what it means. You have home state. You then have investor, and we will go into the definition of investor later in this conversation, because it's a term of art. So there's a specific way you apply the word investor. And then there are the contracting parties. Thank you very much, Kelvin. I will share my screen now. And then you have the contracting parties. The contracting parties are the signatories to whatever agreement exists between the countries in question. I'm going to ask if everyone can see my screen. I suspect that I'm not sharing where the I'm not sharing where the slide is. Please pardon me. I'm going to try again. Just give me a moment, please. I'm sorry. Okay, let me try sharing again. Okay. Okay, can everybody see my slides now? Can
Yes,
you see
we
my
can.
slides?
Yes, we can.
Yes, ma'am.
Excellent.
We
Yes,
can.
ma'am.
Perfect. Thank you so much. Thank you. I appreciate all the responses. So I've given you the excellent. So this is where we were. Yes, so I was saying that we now got into an era where then merchants were having to resort or were having to seek diplomatic protection from their home states. Remember all the terms: contracting party, host state. I mean, we'll get to contracting party later because we haven't started talking about treaties, but home state, host state, and investor, very important. So investors were having to seek diplomatic protection from their home states. And so that's between the 19th and 20th century. And this was known in Latin America as the Calvo Doctrine. Usually these things are named after somebody. So the Calvo Doctrine is named after the gentleman who sort of described what the building blocks were for investment, for diplomatic protection. So the challenge with diplomatic protection was that your home state needed to buy into this dispute. So when you go home as an investor and you tell your home state that this is the challenge I've had doing business in, let's say, let's use African examples, Nigeria and Ghana. So if you come back home to Nigeria and you say, oh, I went to Ghana, this is the issue I had, this is what happened to my business, the Nigerian government has to agree with you and they need to buy into that dispute. Then when they agree with you, they will now enter into diplomatic conversations or negotiations with Ghana. Now, the first challenge that the investor has is because these are diplomatic conversations, you are left out of the conversation. So you come to Nigeria, you meet federal government, you tell them these are the issues, you provide all the information, then they engage with Ghana, you are not in the conversation. And they have a little bit of back and forth. And, if they succeed, then Ghana compensates you or pays you your money or resolves whatever issues you have locally in Ghana. If they don't agree, and Nigeria is feeling like we have might, and you cannot treat our citizens like that and get away with it, it can escalate into tension. Next thing you know, military might. So in an era of diplomatic protection, the diplomacy was referred to as gunboat diplomacy. That's the diplomacy where military might and firearms were now involved. And some countries, bigger countries, will invade smaller countries to enforce their citizens' rights. And in Latin America, for example, the Calvo Doctrine came from Latin America because between the US and Latin America, there were a lot of these issues. And in a particular period of about 25 years, the US had invaded Mexico like 40 times, gunboat diplomacy, just to secure the rights, the commercial rights of their citizens. So obviously, this was not a very sustainable model of dispute resolution. It was very politicized. There was a lot of uncertainty. The investor was not involved. And oftentimes, after all of that hula baloo, there was actually a chance that the investor will not even get the compensation they were looking for. So after egos have left have gotten involved in the dispute and the two governments have fought about it, you may not end up getting the compensation you were looking for. So these were the challenges with diplomatic protection down to gunboat diplomacy. So obviously nations decided to start moving from that sort of arrangement. So I'm sorry, and I missed the older BITs. I've gone straight into the modern BITs. BIT means bilateral investment treaty. That is a treaty between two countries. But the earlier agreements between countries, as it relates to trade disputes or investment disputes, really started with simple agreements around how disputes will be resolved between the two countries if they arose. And this was from around the 1800s. I'm sorry, I missed it in my notes. Otherwise, you will see it there. I'll update it before I send it to Doc to circulate. But this was around the 1800s. The point is, those were very simple. They started with simple agreements. Just, this is how we're going to resolve disputes if a dispute arises between, if a citizen or an investor from my country runs into business issues in your country, this is how we're going to resolve them. So it was very small. The scope was limited. It was just, let's have this conversation and let's resolve the disputes between us, or let's even arbitrate. Let me see if I can find the earliest arbitrations and let you know what that looks like. I'm so sorry, I missed an entire section of my notes. Right, I found it. So the first arbitration of this nature, interestingly, happened on the African continent. It was between a Turkish investor and Egypt, and they appointed Napoleon III as an arbitrator to determine the dispute instead of applying diplomatic protection. So this was in 1864. This was one of the earliest instances of moving away from diplomatic protection to investment disputes. And it's very telling that Egypt is one of the early countries that had an investment dispute that was settled by arbitration. I say so because we will find subsequently in our discussion that Africa was very involved with investment arbitration as we see it today. So having gone over the ancient history, let's come into the modern investment treaties that began to shape the way trade and investment were done. And this time around, they were more detailed. So it didn't just, the agreements didn't just cover disputes. Now they are covering major things like, okay, if investors from the two contracting parties are going to be carrying on business based on this treaty, this is the extent of protection that we will provide. This is the extent of relief they can get. This is the forum they can go to if they have a dispute. This is how the dispute can be resolved. And these are the ways to ensure enforcement of whatever the outcome is. So we had the early, the more modern BITs from 1959, Germany, Pakistan BIT, which was a major template, that set non-discrimination standards for investors from contracting parties, and it also set expropriation standards. Expropriation is another word you should write in your jargon buster. Expropriation means the government interfering with your business, and we will see subsequently that expropriation can happen in different forms. But essentially, if the government does something or takes an action that affects your business, this BIT sets the parameters. What are the standards for expropriation? And so from the 1960s, BITs began to spread, bilateral investment treaties. I'm using BITs loosely here because they are the more common forms of investment agreements. But there are all sorts. There are multilateral investment treaties. There are investment agreements. there are regional agreements. So there are all sorts of agreements that govern trade and investment from around the world. But coming back to investment arbitration, which is the dispute resolution segment of, trade and investment. Investment arbitration was institutionalized in 1966. The ICSID Convention was signed, became effective in 1966. And this is where I say Africa played a significant role. So the ICSID Convention, and ICSID is another word, you should write in your jargon buster. So the ICSID Convention became effective in 1966. And the ICSID Convention needed 20 signatories for it to become effective. ICSID means International Center for Settlement of Investment Disputes. ICSID is set up by the World Bank. There's a whole history around the World War and why the world came together and created an institution known as the World Bank, because we were trying to rebuild everything that World War II had destroyed. That's a whole other history. But out of that, the World Bank came up, and then ICSID, the International Center for Settlement of Investment Disputes, was born. And the instruments that set up ICSID needed at least 20 signatures for it to become effective. And can anybody take a guess who the first 20 signatories? There were more than 20, but where did the signatures come from to make ICSID, to bring ICSID into force? Can anybody take a guess? If you can guess, drop it in the comment section. I've said it a few times that they played a key role in investment arbitration. So this is where that starts happening. Can anybody drop it in the comment section? No? Okay, I will tell you. Africa. Sorry, they needed 30 signatures and 33 African countries. Thank you, Edith, and thank you, Eze. And 33 African countries were the first to jump in and sign the ICSID Convention for it to come into force. So I say that to say that Africa was not only very open to trade, but we were also open to creating an environment that allowed free flow of investment and protecting our investors so that our economies will grow. And this is from pre-colonial times, but by the 1960s, we were now moving post-colonial, and BITs were becoming more common, and countries of the world, including African countries, were opening up to business. So the ICSID Convention came into force, and it provided an interesting or a new way of doing things. One of the key features was that the ICSID Convention delocalized dispute resolution, and this is another jargon buster. Delocalization. It means that dispute resolution, investment disputes, could now happen in a forum that was not tied to any state. So maybe what I omitted to mention here is that some of the remedies that were available to investors before we had proper investment, before we had the ICSID Convention, some of those remedies were restricted or were limited to local courts. So even though you had all these investment treaties and relationships, sometimes the remedies were in local courts. And the general view was that these courts were not unbiased. They were not, sometimes the decisions were stacked against the investor. So one of the changes that ICSID brought onto the landscape was delocalizing investment disputes. So now your investment dispute is not tied to the court of any jurisdiction. It is, so you don't have to seek local remedies. Local remedies is another jargon buster. Write it in your list of words. Local remedies are remedies that are tied to domestic courts or domestic institutions. And in some treaties, local remedies still exist. There are some treaties that say you have to explore all local remedies before you can go to international forum. But these are older generation treaties. The more modern treaties do not have those. So ICSID delocalized those. There was an automatic enforcement regime because of the New York Convention, which I think you should be familiar with. And so, things kind of progressed quickly in that regard. So because you now had the enforcement backbone, investment arbitration under ICSID became very popular, and countries quickly signed up. And as of today, I think we have over 170 members. In Africa, I think we have, out of the 54 countries, we have 51 signatories. As at last year, I'm not sure what the numbers are this year. So out of the 54, we had 51 member states that are signatories to the ICSID convention. So that sort of picked up very quickly. And then because of that, BITs grew. ISDS is another word you should have in your jargon buster, investor-state dispute settlement. So remember that we talked about diplomatic protection and state-to-state disputes for a long time. Before the ICSID convention, really disputes were between states. So even when we had arbitration, a lot of the arbitrations were state to state. So one state had to initiate the dispute against. But with the introduction of the ICSID convention around that period, you now had investor-state disputes, meaning that you, the investor, can now take your case directly to the forum and initiate an arbitration against a state. So in the 1990s, BITs were on the rise. ISDS, investor-state dispute settlement, was on the rise, and it became sort of the default in many regions of the world. But that system also then had its own challenges or its own concerns. It now seemed as though the system was skewed in favor of the investor. Remember that there were all these treaty protections, and we'll go into the kinds of protections so that this will be clear. But there were all these treaty protections, so the investor could quickly run to a forum and start, initiate an arbitration against a state, and if they could establish certain things, they would win. And sometimes the protections meant that, if a state signed a treaty under a particular regime, or they had a certain set of laws, and their laws changed, and it affected another person's business, that person could go to investment arbitration and win against the state. So it's now had an effect on the states. We had a phenomenon which was known as regulatory chill. States were now finding that their power to regulate or to create laws or regulate certain sectors in their economy was impacted by the outcome of investment awards. So states were now becoming careful of what kind of laws they passed, and if they did, that immediately had a negative impact on them, because investors quickly ran to arbitration and awards were given against them for deviating from what they promised under their BIT. So that concern was there. There was, of course, inconsistency. Tribunals were giving different kinds of decisions. So it was not clear how a dispute could be decided. One tribunal could decide it this way, and that problem still exists significantly even today, just because, tribunals see things differently, and there are different systems of laws, and there are different, ways that disputes are understood and resolved. But that was a concern, and then there was the cost, there was the time that it took, and all those concerns, gave birth to so many reforms. The United Nations Working Group 3, you may have heard of them, where different states bring their views on what should be done to make changes in terms of investment law and investment arbitration. That working group, has been reforming and re-reforming the investment arbitration landscape. Different regional courts, have taken decisions that reshaped the arbitration and investment landscape. And then, of course, modern BITs, different countries started entering more progressive, more state-friendly BITs that allowed the states to pass the kinds of laws that were pro their citizens, rather than taking into consideration investor concerns. And we will see some of those BIT provisions. So essentially, the sources of international investment law, as you've seen so far, were treaties. There's customary international law, which sets minimum standards for what should be done. There are general principles of law, which we all know, things like estoppel, good faith, abuse of rights. And then there are secondary sources, case law, which do not create law but are persuasive, law texts, scholarly writings. All of these are the sources of investment law that we will see shape how arbitrations in that space are conducted. And then, of course, in terms of interpretation, you have the Vienna Convention on the Law of Treaties, which tells you how investment instruments should be interpreted. And a lot of investment arbitration tribunals rely on them to understand what the treaty obligations are before they can render an award in an investment dispute. So some of the things that we have sort of established so far, which I want us to bring to the forefront of our minds, or to the fore of our minds, is sort of the intersection or the difference between investment arbitration and commercial arbitration, which I think is what you've been doing so far. So in an investment arbitration, the parties are typically either state to state or investor to state. Commercial arbitration is usually private parties. I'm sure that you learned under commercial arbitration that consent is a necessary pillar or is a necessary ingredient. In investment arbitration, consent is found in the treaty document or the legislation or the investment instrument. In commercial arbitration, consent is found in the contracts. In investment arbitration, the applicable law will be the treaties or public international law, while for commercial arbitration is the contract stroke national law, whatever the applicable national law is. And then in terms of public interests, commercial arbitration is very private. Sometimes it's even confidential if the parties agree. But because investment arbitration affects countries and the rights and benefits that accrue to their citizens, there is increasing transparency. So those proceedings and the awards are they're becoming more and more public, so that the citizens that are affected are aware of these issues. So that's the distinction between investment arbitration and commercial arbitration, which I think we should bear in mind before we go into the next phase of our conversation. Are there any questions at this point, or are we clear and can I keep going? If we're clear, just type clear in the comments. If you have questions, just raise your hand. I'll give 1 minute for that to happen. Oh, sorry, 30 seconds. 1 minute is a lot. Thank you, Marvelous. Is it only Marvelous that wants us to proceed? Okay, thank you very much. I take it that nobody else. Thank you, Ifoma. Thank you, Edith. Okay, so let's move forward. My slide has refused to move forward with me. Okay. So some of the pillars of investment arbitration that we will now, sorry, let me go back. Where were we? Okay, this is where we stopped. So some of the pillars of investment arbitration that we will now look at is what I'm going to go into. And the major thing we will start with is jurisdiction. Jurisdiction is important for a number of reasons, and we will soon see it. I should say from this point on, that I had an opportunity to work as a tribunal's assistant in one investment arbitration that, interestingly, had bits and pieces of everything we're going to discuss going forward. That's how nuanced and how broad that case was. So if I give a personal example and I say case X, just know that that's the case I'm talking about. The reason I'm not naming names is because the award is not yet out. But we are going to start with jurisdiction, and we're going to look at jurisdiction in investment arbitration from two main perspectives. So you will see here that I have the 4 jurisdictional pillars, and those jurisdictional pillars are largely what you find in the investment arbitration, in the investment agreement, in the bilateral investment treaty or the multilateral investment treaty. And then we are going to look at the scope of the jurisdiction of the tribunal. That is not necessarily written in the investment agreement, but it arises from the circumstances around the investment agreement and the dispute. So for those 4 jurisdictional pillars, the 4 main pillars are investment, investor, consent, and attribution. I'll just say what they are quickly, and I'll give you time to write those 4 words in your jargon buster. And then once you've written those 4 words in your jargon buster, I want you to then, if you can see my cursor, you then go to the scope of the jurisdiction and write all these Latin terms that I have. You can write the English version, but also write so that when you see them, you'll understand what they are. And then I'll quickly just mention what they are, and then we'll go into the details. So for every investment dispute, you will find that the word investment is defined. So it's not every investment that is protected. There are certain classes of investments that are protected, and every treaty defines what those investments are. And then you will also find that every treaty defines who an investor is. So it's not everybody that walks into the shores of your country and comes and has some business interaction that qualifies as an investor. So it's not everybody that is protected. That is why these pillars are there. And then there's consent. You are already familiar with consent because you know consent from commercial arbitration. Now, the only difference is that in commercial arbitration, what you know is that there's an arbitration agreement or an arbitration clause in a main agreement, and the 2 parties sign that agreement. That's their consent to arbitrate. Consent is slightly different in investment arbitration, and we will go into the nuances, but consent is one of the pillars. As you know, you cannot have arbitration without consent. You cannot drag someone to arbitration that did not ask to be taken there. And then we have attribution. Because you are dealing with state entities, attribution essentially refers to the actions that you can attribute to the state. So it's not everything that happens to an investor in a host state that can be attributed to that host state. Therefore, it's not every action that causes them to suffer business or financial loss that they will succeed at when they go to investment arbitration. So we will look at those 4 pillars and how they affect or how they limit, what kinds of disputes you can take to investment arbitration. And then we will look at the scope of the powers of the tribunal. We will look at those ones in detail, and I will just move forward from here so that I don't talk too much, so that we can discuss them in detail. But we will look at it in space. Just refers to the geographical space. In time refers to the duration or the validity of the underlying investment agreement. And then the persons refers to, whether that is similar to the investor, whether that person falls within the jurisdiction, qualifies as a person, is a person that the tribunal has jurisdiction over, and then the subject matter of the dispute, whether it falls within the jurisdiction of the tribunal. So you will see that they are connected, but those are the pillars that one has to consider when looking at investment arbitration. So we'll start with an investment. What is an investment? Treaty definitions differ. Different treaties say different things. Some definitions are very open and they're asset based. It means that when in those treaties investments are tangible, they're assets that the investor can own. So it may be, the nature of the business may be such that there are physical assets that you can see. And then some are enterprise based. So, you know, businesses that you may not be able to see and touch, but they're businesses that the investor owns and qualify for protection. Every investment agreement defines the investment differently. And you will find that under the ICSID convention, because ICSID is where you go to resolve disputes, ICSID also has features that must be present for something to qualify as an investment. The general test that is applied mostly in the industry is the Salini test. The Salini test was derived from a case that established sort of the building blocks that you need to consider to say whether something qualifies as an investment. And those include the financial contribution that you make, the duration or the time, over time, and the risk, the business risk that you take in making that investment, and how that investment develops the community or the place that you make that investment in. So those are the pillars that the Salini test, or that's what makes up the Salini test. And that Salini test essentially means, and I've put it in a box there for you to see, that what you need to look out for is that if it's a project that involves some investment of capital, and that capital is at risk over time, and it is aimed to yield returns or profit, then very likely it qualifies as an investment. So some treaties have legality requirements. That means that investment must be made in accordance with the law. So they say it expressly, so that, it's not every investment. If you come and your investment does not comply with the local laws of the host state, then it does not qualify as an investment. And some tribunals, even when the treaty does not say in accordance with local laws, some tribunals will go out of their way to look at whether or not the investment complies with local law for it to be able to qualify as an investment under the treaty in question. Essentially, some tribunals will ask whether the investment was made legally. So they will consider the legality of that investment. And in looking at the violation that the investor is complaining about, they will look at materiality. Is it a very serious should I say what's the language? Is it a very serious infraction, or is it a very serious violation that affected their business? And then they will also look at proportionality. So that claimed illegality, or the claimed illegality of the business, is it serious? Is it enough to warrant some treaty restrictions? And we will come into, I'll explain that a bit more subsequently. You will see I have in bracket there, DOB means denial of benefits. So is the illegality so serious that the investor should be denied treaty protection? That's the question those are the considerations that some tribunals will have before they determine whether an investor can get benefits. I've included some African perspective because I've done some work in that area on the continent, and also because we are all on the continent and that is closer to us. So the Africa Arbitration Academy Model BIT denies protection to investors, to investments that are linked to corruption, anti-money laundering, counterterrorism, financing, and they protect things like biodiversity, traditional knowledge. I'm sorry, the line there is cut short, but essentially the model BIT is a model, as the word implies. So it's in the international treaty space, you will find that some regions have models. So they will draft a treaty that is not binding on anybody, but when countries in that region want to negotiate treaties with another country, that is you refer to that model as a guide. It will help you. And different regions in the world have different kinds of models that they put out there for their member states to adopt. So in Africa, we have what is known as the Africa Arbitration Academy Model Bilateral Investment Treaty, which was drafted in 2020. Was it 22 or 23? I forget now. But you will see that it is one of the more modern BITs, and it limits the scope of what is considered an investment. And one of the ways it does that, it says you will deny benefits or you will deny treaty protection to investments that are linked to corruption, anti-money laundering, and counter-terrorism funding. Okay, the next thing is, who is an investor? So who qualifies as an investor? And the questions that, or the test for that is very simple. The place of incorporation is important. If for most host states, and I'll use Nigeria as an example, you know that a foreigner cannot do business in Nigeria without registering a Nigerian entity. So the place of incorporation determines whether the investor is entitled to treaty protection. So if you register a Nigerian entity, or if you register a business in Nigeria, then, depending on the treaty, I think almost all the treaties Nigeria is signatory to, actually. If you register a business in Nigeria, then you qualify as an investor that can secure treaty protection. Some treaties will look at where is the seat or the headquarters of that business. Is it in the host state? So if what you have is a regional office that maybe is just used to pass on information to other parts of the business in other countries, that regional office may not qualify for investment protection. But if you have the headquarters where the major business is done, investment is made in that economy, if the headquarters or the primary place of business of that, let's say it's a multinational conglomerate, if it has a major office in the host state, then it can qualify for investment protection. Some treaties will also look at substantial business activity. So it's not enough for you to come and just put a building there and put 20 staff and call it your headquarters. If you are not actually transacting real business, there's no inflow and outflow of value to that economy. If there's no substantial business activity, then you cannot qualify as an investor for the purpose of investment protection. And then some treaties will also mention the question of control. The entity that exercises significant control on this business, is it registered in the host state, or is registered in another is registered in another jurisdiction? So where the control comes from can oftentimes also determine whether a business, even though it is domiciled in your country and is registered there and it has an office there, where the beneficial ownership or true ownership of that company is, can also determine whether or not that investment qualifies for, that investor qualifies for investment protection. So you will see that many treaties include a denial of benefits clause, which allows a state to refuse treaty protection to mailbox or shell companies that lack genuine ties to that host state. I'm sorry, the word there should be host state, not home state. Remember the meaning of those words. So those are the parameters for determining who the investor is for the purpose of seeking redress in investment arbitration. And you will see that I still included our African perspective here. The Africa Arbitration Academy Model BIT in Article 16 denies benefits where there is no substantial activity or there's last minute restructuring. Maybe you realize that this country, I can get benefits as an investor. You now quickly restructure so that you can then take the state to arbitration. If you do that last minute restructuring, you cannot be covered as an investor. If you suddenly bring all your business here because you know that this country will give you protection, you will not qualify. Or if you do not comply with domestic law, then you will not qualify for investment protection. So still, this is a quick case store to see how decisions have been taken. So you will see that there's a 2004 here that applied the incorporation test, and because the investor was registered in Lithuania, that's the country there, they passed the incorporation test. You will see the 2005 case, ownership and control test was applied there. You see a 2011 case from Slovakia where substantial business activity test was complied there. And you see a 2018 case where the seat or where the primary where the headquarters or the main business entity is located. That test was applied there and the investor was found to qualify. So the next pillar, we've looked at what is an investment, we've looked at who is an investor. We are now looking at consent as a jurisdictional pillar. Remember where we're coming from. We're looking at the 4 pillars of jurisdiction. We've looked at an investment, what qualifies as an investment, who qualifies as an investor, and we are now looking at consent to arbitrate. So if you go to arbitration, have the 2 parties consented? From the perspective of the contracting state or from the host state or the home state, every state entity in investment arbitration, your consent is contained in the treaty, in the contract, or in the legislation. Some countries have investment act that provides all the terms for investment. So that state consent in those instruments is referred to as a standing offer. It means that once you put in once you include arbitration as a dispute resolution mechanism in that treaty, in the concession contract, or in the investment legislation, once you include arbitration there, you have made a standing offer to every investor that takes advantage of that regime, that if there's a dispute, they can go to arbitration. So for every investor who then decides to invest on the back of that regime, the offer is accepted the moment they file or they initiate an arbitration against the state. So that is how consent is established in investment arbitration. If the state includes arbitration as as the dispute resolution mechanism in the relevant treaty, contract, instrument, or piece of legislative instrument, then they've made a standing offer to arbitrate. Once the investor who has invested following any of these regimes initiates an arbitral proceeding against the state, then consent, that entity or that investor is deemed to have accepted that offer to arbitrate, so consent is established. That is how you establish consent in investment arbitration. Under ICSID, consent triggers a self-contained regime. So remember what we said about ICSID. ICSID delocalized investment arbitration. So you are not worried about, well, that no seat is not accurate too, but you are not worried about things like exhausting local remedies in the host state before the investor can benefit from investment protection. Again, the Africa perspective, the Africa Arbitration Academy model bilateral investment treaty requires consultations and mediation first before arbitration, and it has what is called a joint treaty management committee that sort of reviews the treaty obligations. So any state that adopts that BIT, and if you adopt this JTMC model, it means that before the dispute escalates to arbitration, there will be consultation with that JTMC. And the joint treaty management committee means that you have people from the 2 contracting parties or the multiple contracting parties if it's a multilateral investment treaty. So because you already have people from each contracting state that understand what the treaty provisions are, the first level of escalation is to the JTMC. You can make consultations to ask questions. You can seek mediation intervention before it escalates to arbitration, so that way investment disputes are resolved very quickly at that level before it de-escalates into a full-on investment arbitration. And one of the things that model BIT did, in a bid to make it more suited to the African continent, is it provided multiple fora, including ICSID, UNCITRAL, ad hoc arbitration, and any African institution that has the capacity to administer investment arbitration. And it allows seats in Africa, so you can sit your dispute anywhere in Africa. It also provides for tribunal diversity. Actually, what it provides for is to give priority to arbitrators and third-party neutrals of African descent first. Unless you cannot find someone with that qualification, then you move to other jurisdictions. And then it introduces an interesting nuance, which, to be fair, a number of modern BITs have, the state counterclaims. Because from everything I've been saying so far, what you've been hearing is that the investor takes the state to arbitration, the investor takes the state to arbitration. And it seems as if it is only the investor that has a claim against the state. But remember that the modern BITs have included some protections from the state's perspective. And what modern treaties are now doing is that the state can counterclaim. So you the investor, you will take me to arbitration and you can claim $2 million or $200 million or $2 billion, whatever the value of your claim is. The state has a right to file a counterclaim and also introduce, and that counterclaim introduce a financial claim against the investor. So that is, that's the direction that modern BITs have taken, and Africa is not left behind. Actually, Africa has been in the forefront of the review of modern BITs, and we'll see that subsequently in this conversation. And there are a number of other innovations in this particular instrument that we will not go into. I'll leave it at that. The final pillar we're looking at under the 4 pillars of jurisdiction is attribution. Remember where we're coming from. We came from what is an investment, who is an investor, and then we went to what is, and then we went to consent. The final pillar of the 4 is attribution and state responsibility. So this refers to a state being internationally responsible if its conduct is harmful. If the harmful conduct, is attributable to that state, or if that conduct breaches an international obligation. So attribution necessarily identifies whose acts count as state acts. By that, because you know that when you are bringing a case against a government, it's not the federal government of Nigeria that goes and signs all these instruments. There are ministries, there are departments, there are agencies, and there are subnational entities that sign all sorts of contracts on behalf of government at different levels. So in order for you to be able to attribute the action or the omission to the government of a state, you need to check whose action actually counts as an action of the state, or whose omission counts as an omission of the state, in order for you to be able to then say categorically that the state is now responsible for these actions. And we will look at it. I'm trying to remember, what does RCIA stand for again? This word escaped me. RCIA. That is the instrument that essentially it will come back to me, and I'll give you the full meaning when it does. But that is the instrument that, or that is the legal framework that is consistently applied by ICSID and other tribunals to determine what actions are attributable to a state. And in Article 4, you will see that the first person there is a state organ. So by state organ, you're referring to ministries, regulators, courts, police, governmental branches, more like states. In Nigeria, those will be states. Those are the entities that automatically count as state actors, and their actions can be attributable to a state. So what a ministry does, what a regulatory agency does, what the courts do, we will see that in the courts there's a limited application of state liability to the courts. What the states do, what the courts do, what the police does can be attributable to the states. And I don't know, for those who have heard of investment arbitration, have you heard of what's that case? There's a recent Nigeria case that put us on the map, and we were disgraced. Zongshan. Has anybody heard of that case? For those who have heard of arbitration. Nobody. Okay. So in that case, essentially what happened is this was a free zone authority in Ogun State that was taken over by a state government, and I think they used the police to sort of thank you, Joanna. Articles on responsibility of states for internationally wrongful acts. Thank you very much. That's what RCWA stands for. So essentially, that's the instrument that regulates that the ICSID and other tribunals apply consistently to determine what you can attribute to state as acts or omissions of the state that they can be responsible for. And I was saying that there's a Nigeria case where a free zone, a free trade zone was established in Ogun State, and the state sort of took back that free trade zone, and they used some police force to do it. And that case went to arbitration. And one would think that because it was a state government and it was the Nigerian police, that Nigeria, the federal government of Nigeria, will not be responsible for, will not be liable. But that was not the case at all. The acts of a subnational entity, in this instance, Ogun State, was attributable to Nigeria. So actually that decision was given against Nigeria. So that's an example of what attribution can look like. So a state organ, then entities with governmental authority, state-owned entities, or private bodies that are exercising delegated public powers. Who can think of corporations in Nigeria that are private but they are exercising governmental authority? Just think. If the example comes to you, drop it in the comments. So state-owned entities or private bodies that are exercising delegated public powers, maybe licensing. No, now Dangote is a private-owned entity. It's not exercising state power. It's Nigerian government does not delegate. CSC is a good example. More examples, but CSC falls under state organs. I'm talking about entities with governmental. So these are more like they are registered entities, state-owned entities. They are registered companies. For example, limited NNPC is a good example. So if you think of other examples, please drop them in the comments. But registered entities that exercise governmental authority or delegated delegated governmental authority, or perform acts that are attributable to the state when they act in certain capacities. Please, I want more examples. NNPC is a good example, but I want you to think. There are entities that are owned by government that exercise exactly. Now examples are coming in. Thank you very much. Thank you. So that's in Article 5. I think NEPA is no longer NEPA. It has a different name now. But that's a good example. Then Article 8, direction and night comsat is a good one. Direction and control. So these are private actors, but their conduct is attributable to the state because they have state direction. Some of these examples we're giving are good examples. So, you know, a lot of the examples we're giving, some of them have government ownership, some don't. They are purely private, but government is using them to perform certain commercial functions. So in that instance, because they have the direction and control of the government, remember case X that I mentioned to you. In that case, it is the case X is the case where a government, you know, government backed into the rights of companies in the oil and gas industry. So it's an oil producing state, and they did it through state-owned companies or state-owned enterprises, similar to our NNPC. So imagine you take over the business of a foreign investor and you are a state entity, and you are controlled by the state. So those entities were not owned by the state, but they were controlled by the state. And in that particular case, the kind of control that the state wielded was that the state is the one that appoints all the directors, including the chairman of the board. And as a matter of fact, some of the control exercised by the state is enshrined in the constitution and in the law that regulates their oil and gas sector. So the minister has some powers to make appointments to that company, and it's in the law. So it was that's a clear example of control. So even though those entities are privately owned, they get their directives from the government, and the leadership of the company is appointed by the government. So therefore, when the claimant wanted to establish attribution, the arguments they made in that case is look at the legislation, look at the makeup of the management and board of the company, and see who has the power to appoint them. And then when that country passed the new laws where it was taking over all its oil and gas assets, it named those entities as the entities that those new assets will be passed on to. So those were the arguments that the claimant made to say, even though these are private entities, their actions are attributed to the state because they act under state direction and control. And then the final example of attribution under RCWA is in Article 11, adoption. So even though it's a private entity and it carries out certain actions, if the state's conduct is such that it endorses or adopts that behavior, then that action can be attributed to the state. So that, in a nutshell, is our 4 pillars of jurisdiction. Okay, let me see. I have a little extra here, attribution and state. So, I said we were going to talk about the courts a little bit. So, where the actions of courts can be attributed to a state, such as to give rise, you know, such as to give rise or to give rise to situations where an investor can claim against the state in investment arbitration, is situations where there is denial of justice. So judicial acts can be attributed to the government. An investor can take the government to court because certain judicial acts denied that investor justice. So judicial acts can be attributed to the government, but that responsibility, as I said, only arises in cases of denial of justice. Otherwise, the courts generally is not one of the entities you find in an arbitration, in an investment arbitration, where they are saying, you know, this is the government entity that carried out this action. Okay, so I'll move quickly. Remember, we talked about the scope of jurisdiction, And this time around, when we talked about the scope of jurisdiction, we talked about it in terms of now the powers of the arbitral tribunal, what falls within the powers of the arbitral tribunal. And I'll go over this quickly. This refers to geographical reach. So if an arbitral tribunal under a BIT can only hear claims about investments made in the host state's territory. So that's one thing you will find. Every BIT defines what the territory is. So any investment outside that territory obviously does not fall within the jurisdiction of the tribunal. So jurisdiction ratione loci in space can only refer to investments that fall within the territory covered by the investment agreement. Anything outside that territory is outside the jurisdiction of the tribunal. Jurisdiction ratione temporis, that's in time. This concerns the authority of the tribunal over events that occurred within the relevant time period. So if the treaty enters into force in 2010, but it does not allow claims for expropriation that happened in this example is not okay, unless there is a new wrongful act after 2010. I think I meant to put 2015 there. So some treaties will have like a moratorium period. Even though the treaty came into force in 2010, it may have a period of 2 years or 3 years or 5 years where you cannot initiate an arbitration under that treaty. Some treaties provide that moratorium so that you would have had time to establish your business before you start rushing to arbitration to say you have been wronged. So if that period is one that is not contemplated, is not covered by the treaty, then the tribunal does not have jurisdiction ratione temporis. Their jurisdiction does not extend to that treaty. For example, another example is that a signatory to the ICSID convention can denounce the convention. So when that country denounces that convention, it is no longer a member state. After that denunciation, an investor who is seeking a remedy cannot come to ICSID cannot initiate an ICSID arbitration. But ICSID has what is called the additional facility rules. Additional facility rules covers countries that are not ICSID member states. So even though you're not a signatory, you can agree, that the additional facility rules can apply to you, and an investor can bring a case under the additional facility rules. And in that instance, then the tribunal will have jurisdiction. Remember case X that I mentioned to you. In case X, is a very peculiar situation because the respondent state denounced the ICSID convention, they denounced the ICSID convention and then at some point entered into a settlement agreement with the respondent, with the claimant, which allowed for the additional facility rules, and then subsequently breached that settlement agreement. This is how they ended up in arbitration. And so one of the respondent's objections to the tribunal's jurisdiction was jurisdiction ratione temporis, to say that, you know what, we're not a signatory to the ICSID convention. We have denounced it. So therefore, this investor cannot bring an ICSID arbitration against us. This tribunal has no jurisdiction to try this dispute. So that was one of the objections to jurisdiction that party brought. So that's an example of another area where jurisdiction of an investment arbitration tribunal can be challenged. We have talked about the investor before, so you will see that jurisdiction ratione personae is closely linked to that. This concerns whether the parties involved, especially the claimants, qualify under the treaty or arbitration agreement. So a company must meet the treaty's definition of investor before it can qualify. We've talked about that. Then the final one is ratione materiae, over the subject matter. This refers to the type of disputes the tribunal is empowered to hear. An example is a tribunal constituted under a BIT may only hear disputes related to treaty breaches, e.g. expropriation, FET, but not purely contractual disagreements unless the treaty extends jurisdiction. So you will find that there are instances where this is a purely contractual disagreement, nothing to do with the treaty, and an investor will seek to bring it under investment arbitration, and unless the treaty expressly provides for those, the tribunal will find that it has no jurisdiction, ratione materiae. Again, in case X, this was one of the objections that the respondent brought to the jurisdiction of the tribunal. And why did they do that? Because they had service contracts with the claimant that predated that were outside the time when they were signatory states to the ICSID convention. So again, ratione materiae was an issue there because the contractual agreements, were existed outside of the scope of the treaty in question. Those agreements predated the treaty. I'm sorry, not the ICSID convention, predated the treaty. So jurisdictional objection, ratione materiae, was raised by the respondent in that case. So these are the different considerations when it comes to jurisdiction. So once you have looked at all these criteria, or you have settled all these criteria, then an investor can have a case in investment arbitration. So that said, what then are the core protections that an investment treaty provides to investors? I'm going to try to cover this very quickly because our time is running, but I'm going to cover 5 key protections. There are a number of others, but these are the major ones. And the first one is expropriation. I think everybody is familiar with that. Expropriation can be direct or indirect. That means that a government will take over your assets, or they will pass a law that scraps your business completely, or reduces the size of your business, or just generally affects you. And because of that, the investor will find that they've lost all the investments they've made in that jurisdiction. Now, what is direct expropriation? Direct expropriation is when the government directly takes over your assets or your business. That happens a lot in the oil and gas industry, where the government can give you a concession over a large acreage, and then they can come and back into those rights and say, sorry, we are taking over this asset, or we are taking over this license. And we have seen many of those cases go back to court, especially in recent times, because a lot of oil producing companies are taking back ownership, countries are taking back ownership of their natural resources. They're reducing the size of concessions, they are changing the terms of agreements that they have, and so there are a lot of investment disputes in that space. So direct expropriation is when an asset is directly taken. Indirect expropriation then targeted at your business, affects your business sector in. So direct expropriation, that benefit, a government can have a defense And the instances are that direct expropriation must meet public purpose. It must follow due process, because there are reasons why a government can take over an asset. So those reasons must be for overriding public interest. Thank you very much. They must follow due process. The law was they were substantially deprived of the use, the value, and the control of that investment. And usually that needs to be balanced against the measure of force that the government used to, implement whatever it is that caused that that resulted in that expropriation. So indirect expropriation is a little bit less is not as clear cut as direct expropriation. So oftentimes the investor needs to establish that in fact this government action or inaction is what impacted my business, and this is the quantum of the damage, and this is why I am entitled. So if the government does things correctly, it cannot amount to expropriation. That's the bottom line. The government can only be said to have expropriated your assets if they do not do things as they should. So to be lawful, expropriation must meet 4 requirements: public purpose, non-discrimination, due process, prompt, adequate, and effective compensation. So that's that for expropriation in terms of treaty protections. Remember that now we are talking about treaty protections. We have left jurisdiction. We are now talking about in the treaty documents. Remember we said that if you cast your mind back to everything we've said so far, we said when countries moved from diplomatic protection to investment treaties, in the early agreements it was just about resolving the commercial disputes. But as those treaties cover broader issues, then the treaties began to outline key things like what is an investment, who is an investor, what investments or what protections does the treaty provide. So if you remember, we've talked about those investments, we've talked about who investors are, we've talked about what investors need to establish before a tribunal to be able to make a claim that their investment has been impacted by state action. We're now just looking at what the core protections are under investment treaties. And we've talked about the first one, which is expropriation. So the protection here is that the treaty will protect the investor of the contracting parties against unlawful expropriation. Lawful expropriation is not a problem, because even though you lose your business, you get compensation for it. What the treaty protects the investors from contracting parties against is unlawful expropriation. So that's protection number 1. Protection number 2 is what is called fair and equitable treatment. Please write it in your jargon buster. I'm sorry, I just put the what do you call them when you use the first letter of each? Not mnemonics, something else. Anyway, I just put FET there. Please write fair and equitable treatment in your jargon buster. The second protection is fair and equitable treatment. In traditional investment treaties, fair and equitable treatment was very broad. Essentially, what fair and equitable treatment meant was that you were supposed to just apply the same fairness to all investors in your jurisdiction, and there was not a lot of consideration for what that amounted to for the state, for state actors, or even for local investors. And remember what we said about regulatory chill, that because in the early treaties, investment disputes seem to favor investors a whole lot. Regulation was now an issue for state governments. Every time you passed a law, you ran into trouble. Somebody sued you and you paid heavily. So that was beginning to affect regulation. Remember, we mentioned regulatory chill. If you can't remember, write it in your jargon buster and go back and look at the notes later and see what regulatory chill means. Or even just ask Google, it will describe regulatory chill for you. But write it in your jargon buster, because that is one of the issues. Fair and equitable treatment, let me put it this way, and I've put it in notes, you will see it there in the slides, that it is heavily litigated. That's because a lot of investment disputes were brought under the header of fair and equitable treatment. In the earlier first generation treaties, those investments, fair and equitable treatment was such a broad protection that almost anything could come under fair and equitable treatment. You just needed to show a little bit that the government did this, it worked for these people, it did not work for us, so therefore we're entitled to some kind of compensation. So typically for fair and equitable treatment, tribunals will examine things like no denial of justice, no arbitrariness, and the protection of legitimate expectations of the investor. Once you can establish that the government's act was arbitrary, or you were denied justice, or your legitimate expectations were cut short, there was a likelihood that you were going to get an award against the host state if you went to investment arbitration. But investment treaties have kind of moved, and you will see that many regions of the world, in the notes there you see that it says across Latin America, the EU, North America, Africa, and much of the Asia Pacific region, modern treaties have abandoned the open-ended FET standard and replaced it with either customary minimum standards, an exhaustive list of specific obligations, or no FET clause at all, to prevent overly expansive arbitral interpretations. So these were lessons learned from just being dragged to arbitration and paying heavily for the kinds of outcomes that those arbitrations, or the kind of outcomes that were rendered in arbitral awards. So to bring it to Africa, the Africa AFCFTA, I don't know, some of us call it AFTA, some of us call it AFCFTA, but we know the free continental free trade agreement that exists among all African states now. It is regarded as one of the most ambitious investment cooperation, trade and investment agreements, because it covers a very large trade area. This continental free trade area, I think, is the largest in the world. So it's a very bold and a very daring investment agreement. A very daring treaty, and it has an investment protocol. The investment protocol, I think, came into force in 2023. And it has an FEC clause. It excludes fair and equitable treatment altogether, and it replaces it with a very narrow set of obligations which focus on denial of justice, procedural fairness, and non-arbitrariness. So you will see that on the African continent there is a shift away from the broad fair and equitable treatment clauses that used to exist in bilateral investment treaties and multilateral investment treaties to a narrower set, of protections when it comes to the right of the state to regulate. So in your jargon buster, please write right to regulate, as in RIGHT. So the state's right to regulate is an important factor in the way modern treaties, especially in the African continent, are now drafted. So the FET standards have shrunk so that they will allow the state's right to regulate to flourish, for want of a better word. So you will see that in modern African treaty practice, the Pan-African Investment Code, which is applicable mostly in Southern Africa, and the SADC, that's South African Development Community Model BIT, so that is a Model BIT also in Southern Africa, removes broad FET standards and substitutes it with specific due process-based protections instead of fairness or legitimate expectation doctrines. In fact, in the SADC region, what they have now is FAT, fair administrative treatment. So states are allowed to regulate, but in their regulation of any sector, they just need to be fair in their actions. So SADC region has taken out equitable and replaced it with administrative. So my job as a regulator is to ensure that I administer this industry fairly. That equitable treatment, you know, African states were finding that sometimes their own investors, the local investors, you know, were on the back foot, and they didn't want a situation where foreign investors can consistently take you to court for a measure that local investors are accepting because you are the regulator, but foreign investors are using that same measure to take you to arbitration and to win those arbitrations. And so this is why FET standards have changed significantly, and in some regions they are now called FAT. Okay, I've dropped a few examples of the African instruments. I will just leave that for you to read in your spare time. And then the next protection is full protection and security, FPS. This is often attributed to physical protection of business assets. So this is protection from violence, destruction, unrest. Foreign investors expect that you protect their property when there is violence and unrest. Again, modern treaties, you know, have tried to limit that. If it is general unrest or general violence, you cannot separate foreign investors from local investors. I mean, the government has general responsibility to protect everybody, so whatever applies to the local investors should apply to foreign investors. And then some modern treaties have expanded FSP to legal security. So they're now saying that not just the physical protection of businesses, but legal protection, stability, predictable, non-arbitrary legal and regulatory environment. Some modern treaties have it, some don't. I have another quick case store here. Let me see. This is an ancestral arbitration, and the tribunal held that FSP included legal security. So in this case, legal security, FSP was extended to legal security. In fact, in the top cases, the top three, 1 ancestral, 2 ICSID. But then there are more recent cases that have actually refused FSP. The tribunal held that legal security was not part of FSP unless the treaty expressly provided so. So treaties differ on that, and sometimes you will find that even tribunal decisions also differ on that. So many modern treaties, including African reforms, have rejected FSP as legal security and reverted to the narrower formulation. You can see the SADC region is in front, Nigeria, Morocco, BIT, which is one of the leading modern, leading templates in terms of modern bilateral investment treaties. The Nigeria, Morocco, BIT. This one is this is not an African BIT. This is US and Canada. US, Mexico, and Canada treaty. That one has also linked FSP to customary international law, which covers police protection but does not extend to regulatory stability. So the US, Mexico, Canada treaty actually excludes legal stability in terms of FSP protection. Okay, the next one is national treatment and most favored nation treatment. So this is another protection that is provided under investment treaties. The national treatment requires the host state to treat foreign investors no less favorably than domestic investors in like circumstances. This is a fairly straightforward protection, and I think that it has not been subject to too much dispute in the investment space. MFN, most favored nation, that's what MFN means. Most favored nation requires treatment no less favorable than that given to investors of any third state. That has had a little bit of issues in the investment space, and we'll discuss them. MFN clauses often come with carve-outs or exceptions, especially when it comes to taxation, financial services, dispute settlement, depending on the way the treaty is drafted. The reason you have these carve-outs, again, is because taxation falls within the state's right to regulate. Remember, we've talked about right to regulate. And sometimes, if you leave taxation within the sphere of investment treaty, then the state cannot levy taxes the way that it wants to. It cannot place restrictions on certain types of goods that are coming into the country simply because a foreign investor is the one that is bringing them. So if the state's regulation changes in a particular direction to support, for instance, domestic production, if taxes are not exempt from MFN protection, next thing you know is that some sectors that are affected by a new tax regime that is discouraging certain kinds of imports will all be able to go to investment arbitration and secure great wins. So MFN has had some measure of controversy, also because sometimes it means that if you have negotiated certain terms with a particular country and a different set of terms with another country, because you have most favored nation, and most favored nation says you cannot treat the investor of another country better than the investor under this particular treaty, it's almost like exporting the terms of another treaty into the current treaty. So those nuances have meant, certain changes in the way governments across the world, including Africa, have looked at MFN provision. And if you look on your screen, you will see that I have national treatment and MFN provisions in a box at the bottom of the screen. And I'm going to go to the MFN provisions because I think that national treatment is fairly straightforward. It's MFN that has had, that has been heavily impacted by modern reforms in investment treaties or investment law in general. So MFN is heavily restricted under the Nigeria-Morocco BIT, and you can see the carve-outs: ISDS, taxation and financial services. MFN is removed entirely in the SADC model BIT to prevent treaty shopping. How do I describe treaty shopping? Okay, I'll think of it and come back to you with an example. PIKE, Pan-African Investment Code, also has no MFN clause, preserving maximum regulatory space. So you can see the way the African continent is thinking. Under the AFCFTA, MFN exists, but it has sweeping carve-outs. Again, ISDS is taking out: tax, financial regulation, public policy, for the same reason, so that you are preserving the right of the state to regulate. So that's very important. There are a few cases stated there. The last example I gave there is the Africa Arbitration Academy Model BIT in Article 7, which has MFM but also has sweeping carve-outs, just the same way the AFCFTA has sweeping carve-outs. I should say that the Model BIT was the inspiration behind some of what is contained in the investment protocol of the AFCFTA. And I would like to think that that's the sort of direction that a lot of investment instruments on the continent will be taking going forward, unless something happens to inspire even more significant changes in that space. So the final protection we're going to be looking at is an interesting clause called the umbrella clause. I call it interesting because every time you see the word umbrella, is a catch-all. That's where the catch-all implications are. Once somebody says umbrella or omnibus, you know that it is catch-all. So what the umbrella clause does is that, similar to MFN, it can take you outside the provisions of the BIT. The umbrella clause essentially just says that, more or less, that the contracting state would comply with all their treaty obligations. And sometimes, this means that, I wish I had put an example of an umbrella clause in this presentation. But sometimes it means that, the clause may be, simple contracts may be elevated to treaty status, depending on how an umbrella clause is couched in a treaty. So the breach of a contract with an investor may become the breach of a treaty. The limitation here is that the application is highly treaty specific. So unless the treaty actually has an umbrella clause, this is not something you come across very often. And sometimes even when the treaty has an umbrella clause, the drafters try to limit the scope of that umbrella clause. But how umbrella clauses are applied differ from tribunal to tribunal. Some tribunals will apply the clause broadly, covering almost all commercial or contractual governmental obligations, while others will require some kind of sovereign act for them to be able to, limit the umbrella clause to specific undertakings. So I've noted here that modern tribunals are split between the broad and narrow readings of umbrella clauses. But African treaty practice, as we see again, largely rejects umbrella clauses to prevent contractual disputes from becoming treaty claims. So all the treaty instruments I've mentioned in that paragraph actually have rejected the umbrella clause for the reason that you don't want to catch all government obligations, all government contractual obligations, and elevate them to the status of a treaty obligation. And I've put in a Kenya, an example of a case from Kenya. This is a 2018 decision where the tribunal refused to transform licensing or regulatory commitments into treaty obligations. So an investor, for breach of a specific license, sought to promote that license to breach of a treaty obligation, and the tribunal refused to do so. This is a clear demonstration of Africa's policy choice that a contract is not equal to a treaty unless a treaty obligation, unless the treaty expressly says so. So some of the final things we will then be looking at is, having seen what jurisdiction looks like, what treaty protection looks like, we will look at the kinds of defenses that host states typically bring to International Arbitration Forum. And I think that in the course of our conversation, we have covered all of these things. And if you remember, in some instances, I gave examples of the kinds of defenses that states or respondents brought to the table when they were taken to investment arbitration on the back of some of the issues that we discussed. So we've gone over quite a number of these defenses, but I thought that this would be a nice way to wrap up our conversation. So I've put them together sort of back end to sort of close out our conversation so far. So host state defenses when they are taken to arbitration in relation to investment disputes is, one, it does not qualify as an investor or an investment. So based on the treaty, remember all our jurisdictional pillars, investment and investor, those were two of the pillars. So that's the first defense. If the claimant cannot satisfy the tribunal that the treaty's definition of investment or investor has been met, then the tribunal has no jurisdiction. So that is, when it comes to jurisdictional objections, that's the first thing respondents usually raise. This is why treaties have circumscribed the definition of investment, have limited them, and put in the carve-outs and the sort of limitations we discussed earlier. So jurisdiction, no consent to arbitrate. Again, that's a defense. States can only consent through treaty text or an investment contract. If the claim falls outside the scope, then jurisdiction should fail. Another defense is denial of benefits. This is used to exclude investors that lack a genuine link to the host state. I keep saying home state. E.g., mailbox or shell companies. If there's no genuine link, then one of the defenses the host state can come up with is, I'm entitled to deny benefits to this investor under the treaty because this investor does not meet does not have any genuine link or does not qualify under the treaty because he has not met the requirements for substantial business within the host state. And then remember we discussed illegality. A defense is illegality of the investment. If the investment was made in violation of host state law, then tribunals may deny protection. So that's a defense that states come up with fairly regularly. And I'm sure those that have heard of investment arbitration before will remember the P&ID case, where there was actually an award against Nigeria, but Nigeria was able to get that award set aside because it established that the underlying contract was procured through fraud. So if the underlying contract was fraudulent, you cannot now come and win an award and get compensation from the host state. So illegality is one of the defenses that host states can raise in international tribunals. Abuse of process. Remember we talked about this. If you already go and restructure, this is also treaty shopping. You know, if you see that, I said I'll give you an example. So this is it. This is also treaty shopping. If you see that, this treaty suddenly provides this set of protections, and then you quickly go and restructure your business so that you can then benefit from this protection, then it is very likely that if on the back of that restructuring, you now decide to go to arbitration, it's very likely that that claim will not succeed because this restructuring was done after the fact with the intention of securing benefits under the relevant treaty. So the tribunals may dismiss that claim as abusive. Those are some of the defenses that host states can raise, and then those are all procedural or preliminary. In terms of merit, some of the defenses that host states can raise is they are not liable because the action that they took was bona fide, it was non-discriminatory, and it was done in public interest. For example, health, environmental, safety concerns. And if you look at the more modern African BITs, including the Africa Arbitration Academy's model BIT, you will see that apart from environmental protection, you will see things like intellectual property rights, arising from use of indigenous or cultural arts, recipes, things that are, Nigeria has a lot of, it's a very diverse country, and we are on the global stage now. There's a lot of attention. And it's not just Nigeria, a lot of African countries, tourism, food, arts, culture, all of it is in the public stage. And what these BITs are trying to protect are the intellectual property rights of the indigenous peoples whose cultures you are now, putting on the global stage and making some form of revenue from. So if the government makes a law that protects those indigenous people, that protects their intellectual property rights, an investor cannot now angrily run to investment arbitration and say, on the back of that regulation, I'm no longer making money, or I have to share more money with the local community, so therefore I'm entitled to compensation. These are the kinds of protections that a state can raise as defense. I passed this law in the public interest for the preservation of these ethnic or cultural or trade secrets. Or if you read the Africa Arbitration Model BIT, we called it ASIRI because we could not find an English word that could capture the essence of some of those traditional things. But the point is, these are defenses that a state can raise to say lawful, or this within my right to regulate. This was bona fide, it was non-discriminatory, and it was in the public interest. And then, of course, state of necessity. A state may avoid responsibility if the measure was the only way it could safeguard an essential interest against grave and immediate peril, and it did not seriously impair the interests of the state. So the examples I gave are good ones. There are instances, I think it was in the South region where I'm trying to remember the case now, it escapes me. They were running a highway through a forest that had some endangered species, and the government had to I wish that case would come to me now. I didn't even think of it when I was preparing these notes, otherwise I would have searched it and put it in there. But so, like, imagine like a massive infrastructure project that the government has to halt because you want to preserve, certain forest reserves that had some endangered species. Those are the kinds of things that the government will say, I couldn't find any other way but to halt this project and say you cannot pass through this. You have to reroute it. It will cost the investor more, they will lose money, they will lose time, but there's no other way to preserve this place and the natural resources that are in here, or the natural life that is in here. The only way to preserve it is to stop the infrastructure development from passing through that region. That's an example. So those kinds of things are defenses that states can raise to say, look, I'm sorry, you cannot hold me internationally liable in this instance because it was in the public interest, or for the preservation of this essential right, and there was no other way to have done it. And then sometimes the government can raise contributory fault. This is where the investor does not mitigate their loss, or in their own conduct contributed to the harm. So poor business decisions, regulatory breaches, these have been known to significantly mitigate the size or the value of awards against host states where the investor did not take the relevant mitigating steps to ensure that they preserve their business in spite of government action or new government regulation. I think we have covered everything that we have for this session. Are there any more questions or are there comments? I've overshot my time by about 10 minutes, so I don't know if I can take questions or comments, but if there are any, this will be a good time to share them. I'm sure Kelvin or Doc will let us know if we have room for that. Thank you. Is our administrator still here, Kelvin, or Dr. Aderemi? We have come to the end of the session.
I am here. Thank you. Thank you very, 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 very much. This was such an insightful class. I know that if we had given you 4 hours, this is probably not enough to unpack all the things that you have in your notes.
No, but I think we've covered the basics. I think we've covered.
Yes, I agree with you. Thank you very much. I don't know if we have chance to take, if there's just one question because of our time, it won't make sense for us to have this kind of class and not have a question. So, I mean, and the question should be that without this gathering, then we didn't achieve something if you don't have that question. Just one question, and then we wrap up the class. Do we have anybody? Short, brief question. Okay, so a question from Joanna. I am a new wig, and I am wondering if a foundation in litigation is necessary for a career in ADR arbitration. Okay.
Joanna, thank you so much.
Answer the question. Thank you.
Thank you so much for this interesting question, and I'm laughing because this question is talking to me. So I think that a background in litigation is good, is great. I don't know if it is necessary. The reason I say I do not know is because I do not have a litigation background. So I cannot tell you for sure what I'm missing by not having a litigation background. But I managed to move from, my career went from legal research to commercial transactions to arbitration and ADR. So I skipped litigation altogether. I think I'm doing okay, but like I said, because I have no litigation experience, I cannot tell you if I'm actually missing something. So I think that litigation experience is good. I don't know if it is necessary. I don't have any. Thank you. Somebody is raising their hand. I don't know if I have permission to ask you to speak. Somebody is raising their hand. I'm sorry, I can't see you. I can't see the name.
Favor.
Uh-huh.
Favor. Her name is Favor. Favor, please, 1 minute, ask your question.
Okay, thank you very much, ma'am. I found the session really insightful. So my question is, as a member of CIHAB UK and as someone who is interested in investment arbitration, I just want to understand how best I can position myself to get practical hands-on experience in investment arbitration specifically. So, and I like the fact that you mentioned that it's not necessary to have a litigation background before I can understand investment arbitration. So
Yeah.
I'm encouraged and I want to understand how best to learn the ropes along my early stage of career. Thank you.
Okay.
Thank you.
Thank you. Thank you so much, Favor, for that question. That's an interesting question. I would recommend um, I would recommend that a good place to start would be looking for some exposure in terms of commercial arbitration. And I'm sure that you will remember the differences. Commercial arbitration usually mostly involves two business entities. So these are smaller disputes, and you will find, well, not necessarily, there can be some really big commercial arbitrations. But my point is, commercial arbitrations, especially for the smaller commercial disputes, tend to be less complex than investment disputes. So commercial arbitration is a good place to start if you are looking to eventually find yourself in investment arbitration. As the name implies, because investment arbitration usually involves state parties, those disputes can be really large, and they, in terms of volume, you will have, in any given jurisdiction, you will have far more commercial arbitrations than investment arbitrations. So it's good to start where you have volume, and you can, by the volume of cases you do, quickly build skill and build credibility before you start to work on major investment arbitration. So that's a good way to start. In terms of the funnel of opportunity, I would say take the certifications, attend courses. If you are able to find yourself in law firms that do arbitration, that's also a good place to sort of position yourself to find those opportunities, because it can be a bit difficult if you are a young practitioner and you're practicing in a space where arbitration is not their mainstay, or they don't have a lot of arbitration. So those are ways that you can position yourself so that you can build capacity. You can start small and then scale until you can do the really big investment disputes. I hope that answers your question.
Absolutely. Thank you very much, ma'am.
Thank you,
All right.
Favor.
Thank
Kelvin,
you.
back to you.
Thank you very much, our keynote speaker for today, Mrs. Laura Alakija. Thank you for your time. It was a time well spent. Well, for me personally, it was a time well spent, and I believe for all students here, because this is a school, it's a time well spent. Thank you very much, and we hope to get your paper I probably have to send you an email or get your contact, and I'm going to send you an email
Yes,
to get
I
your
will
feedback.
clean it up
And
and
then,
I'll share it with you. Sure.
oh, fantastic, fantastic. Thank you very much, Miss Laura, and thank you everyone for joining in. Thank you for having this time. This is 2 hours, 20 minutes well spent. Yes, thank you very much, and do have a beautiful weekend. Before next week, we are going to get the recording of this session, and then we can go back to watch it and make comments and then prepare for our next class. Thank you very much, and Miss Laura, have a beautiful weekend.
Thank you very much. Have a nice weekend, everyone. Bye.
Thank you so much. No, that's the same.